Good afternoon. Thanks so much for coming. My name is Laura Heisler, and I am Director of Programming for the Wisconsin Alumni Research Foundation, and I am delighted to welcome you to this semester's first WARF Essential Topics. We're going to be talking about consulting agreements, and we have a phenomenal panel of campus experts to guide us through that, and this session will be moderated by my colleague, Angie Kuyak, Assistant General Counsel at WARF. Before I turn things over to Angie, I just wanted to give you guys a couple of housekeeping notes for how this session's going to go and what's going to follow. So I see most of you have a name tag. If you don't have one already, you'll want to grab one if you intend to join us for the networking reception. When this session concludes at 5 o'clock, you'll be invited to step behind you to the South Atrium and stick around for additional conversation over food and beverages, but it helps if you have a name tag because we definitely want the reception to be for the benefit of the people attending. So grab one of those. If you are not on our mailing list, if you heard about this through word of mouth and you'd like to get emails for future essential topics, please do sign the sheet that's out by the registration table out there, and then we'll make sure you're on our mailing list for future events. And then most importantly, there'll be 45 minutes or so of discussion amongst the panelists and presentations from the panelists, and then there'll be a time for audience question and answer. A lot of you, I'm sure, are here to ask some specific questions. We do ask that you wait for one of the mic runners to reach you. We videotape all of these sessions, and we want to make sure that your question is captured on the videotape. And if you're interested in watching this later, or if you have colleagues who heard about it and couldn't make it, that videotape will be up on the WARF website within a couple days. I think it's probably a safe bet to look into early next week, and you'll find that video if you do want to capture this or watch it again. So with that, I will turn things over to my colleague Angie Kuyak to get things started.
Hi, Angie Kuyak, Assistant General Counsel. I'm losing my voice a little bit, but I think I can make it. Thank you for attending. We think this is a very important topic, and we hope to clarify 3 main points for you tonight. 1, what are the potential conflicts that can arise in a consulting arrangement? We often think about the more traditional type of conflict when the consultant has a ownership interest or other proprietary interest in the company, but there are other potential conflicts that can arise, and we'll try to highlight those for you. 2, what are the procedures and policies on campus that dictate the treatment of consulting agreements? So for those who are researchers in the audience, what do you have to do in order to consult for a company? And it's also interesting, and I see a couple people from industry here, what would be good for you to know what needs to be done prior to entering into a consulting agreement with a researcher on campus? And finally, what resources are available to you as a researcher? And those resources may differ based on what capacity you are consulting in. Is it in your personal capacity, or is it in your capacity as a UW employee? And we'll explain that with Jeff Glazer from the Law and Entrepreneurship Clinic. And so the format is we're each going to present about 4 to 5 minutes worth of information, and then we're going to open it up to questions. And so to introduce my panel first, I have to my left Dr. Ann Palmenberg, who is a biochemistry professor on campus. And we included Ann on the panel to provide the researcher's perspective, to get an idea of how it comes up, how consulting arrangements come up in her everyday work, and the types of issues and questions that she sees that arise during that process. And for the next 3, I'll have each of you introduce yourself with your name, title, and where you fit into the process. That'd be great.
Sure. I am Stephanie Leroy. I am the Conflict of Interest Specialist in the Office of Research Policy, and I work with conflict of interest with investigators.
And I'm Rochelle Martin. I'm the Assistant Director of the Office of Industrial Partnerships, and our office is the primary office that's going to be negotiating research agreements that are with industry sponsors.
Jeff Glazer with the UW Law and Entrepreneurship Clinic. I'm a clinical assistant professor at the L&E Clinic. Of the many things that we do, I'm in charge of working with faculty when they come to us for their consulting arrangements.
So you can see we have a very diverse group here to provide different perspectives on the process. And first, to start out the conversation, it's really difficult as an attorney. You're often judged on bad things not happening. So to grab people's attention, it can be challenging if you're doing your job. But thankfully here we have an example of when things did go awry. And luckily didn't have to do with UW-Madison. It's always more interesting when it involves another university. And here it was Stanford. And it's a famous case from the Supreme Court, came out a little over 5 years ago, Stanford v. Roche. And it involved a researcher, an employee at Stanford, who visited some researchers at CETUS, Some assets of Cetus were subsequently acquired by Roche, some PCR assets. And then he went back to Stanford, maintaining his employment the whole way through with Stanford. An invention arose, a dispute stemmed from that, and I'll run through a timeline, and it's a sequence of events here that's important. And so here you'll see, first, he signs what was referred to as Stanford's Copyright and Patent Agreement in 1988. A year later, he visits the researchers at Cetus and signs a visitor's confidentiality agreement. He subsequently goes back to Stanford, an invention arises. Stanford elects to retain title. Stanford has that right because it's a federally funded invention under the Bayh-Dole Act. Universities have the first right to retain title, and Stanford elected to do so. A couple years later, Stanford had the inventors execute assignments specific to the particular invention. Stanford subsequently attempted to license Roche because they noticed Roche was selling products that infringed their patent. Roche resisted. Stanford sued Roche in district court, and it made it up to the Supreme Court. But we'll set that aside. So on the last slide, I'll just go back to that one more time, is if you notice the order again, is that he signed the Stanford Agreement first, and then the Cetus Agreement. So that'll become important later. Here's the front page of each agreement, just so you can get an idea of what they looked like. The Stanford Agreement, the Patent Agreement, is something that with a title you'd expect probably assignment of inventions was discussed, and in fact it was. Versus the Cetus Agreement, the Visitor's Confidentiality Agreement, probably not the title that tips off the researcher that there might be IP terms speaking to assignment of inventions, but we'll get to that. And so then we went to the Supreme Court, and the Supreme Court said, hey, Stanford, it doesn't matter what order he signed the agreements. It doesn't matter what they were titled. It doesn't even matter, and this was the central focal point of the decision, it doesn't matter that it had federal funding. That doesn't save your claim. We have to look at what the words of the agreement stated. And so this is where what you sign really does matter. The Stanford Agreement, which he signed first, a patent agreement, stated, I agree to assign. While the Cetus Agreement, and again, their assets were acquired by Roche, hence why they pulled this agreement into the lawsuit, it stated, I do hereby assign. And the court concluded that the hereby assign in the Cetus Agreement meant an assignment in 1989. It was a present assignment, where that Stanford Agreement back in 1988 was a promise to assign sometime in the future. So when Stanford elected to retain title, they didn't have anything, in fact, to retain, at least with respect to this researcher. There were other Stanford researchers, so they still owned part of the invention, but they had nothing to elect on behalf of this researcher. And when the researcher assigned the specific assignment to Stanford, and I'm sure the researcher thought he was assigning it to Stanford as well. This is an after-the-fact pull out of the records type analysis. But they concluded as well that he had nothing to assign to them because he had, in fact, assigned his interest back in 1989 to Cetus. And again, the assets being acquired to Roche. Roche no longer needs a license because it has a partial interest in the invention. So this sets the stage. And for what we're going to talk about today, why they're important, to try to capture your interest a bit. But this is not to say that it's our intent to derail or diminish collaborations. We don't want to stop them or prevent them from happening or slow them down. We actually want to foster them. We encourage them, and we want both sides, and the industry as well, to get what they are expecting out of a collaboration or a consulting agreement. And so that's what we hope here, is to clarify the process so everyone has more confidence into what they are acquiring from the consultant, and the consultant feels more confident that they can provide the services without creating conflicts on campus. And with that, I'll turn it over to Anne, if she could just provide a little bit about how consulting agreements have come up in your everyday work.
I think there is a slide. Thank you. All right, everyone can hear me, and I've got a loud voice. So I'm the faculty representative here to show you what kind of trouble you can get into if you don't have a whole panel of lawyers working for the university to help sort things out. So I am a researcher, a faculty member, been here for 40 years. I work for the Institute for Molecular Virology and the Department of Biochemistry. And my current research is on viruses, particularly those which cause asthma. And over the last 2 years or so, we've had some rather remarkable breakthroughs in that area. If you want to learn about the science, go to my website. But we work on viruses and asthma, and obviously both of those topics are of great concern to national health and also to many pharmaceutical firms. So not surprisingly, my work is funded by the National Institutes of Health. They're very interested in both of these areas, and they give me money through R01s and standard grants to do this. Every once in a while, particularly in the last couple of years, we've come up with some really, really good ideas on the relationship between viruses and asthma. And as good UW faculty members, of course, we take that information to WARF. And we go, hey, we've got these really hot ideas. We know the pharmacos are going to want in on this. And so we file the IDRs, and we file, WARF will file patents on our behalf. And we give them, for example, our reagents, new reagents that we've created, and also the ideas about how to cure asthma working with our information. And that, of course, hopefully, is lucrative information for WARF. WARF goes out to the pharmacos and say, hey, we've got these new patents that we are dealing with. And the pharmacos go, yay, we can make new products. We can make new vaccines. We can do all kinds of stuff with that information. So they sign MTAs or licenses with WARF for our reagents or for our patents and for our ideas, and that's all great and wonderful. At this point, there's not a whole lot of conflict. Everybody's happy. Money is exchanging hands. People are fine. The problem is the pharmacos don't have 40 years experience working in this field. So they take our reagents and they go, we're not really quite sure what to do with this stuff. So if we want to make an antiviral, maybe this is the right assay, maybe that's the right assay, maybe this is the right assay. I know, let's go ask Anne. So they set up consulting with me, right? And that is personal between those companies and me. They say, hey, can you teach us how to make a vaccine? Can you do whatever? My research is public, in the public area, because I am publicly funded and I work here at the university. But if you want me to comment on your particular vaccine technology, then you've got to hire me to do that as a private consulting thing. And it keeps your research, if you are a pharmaco, proprietary. So I can sign consulting agreements with these pharmaco groups. While I'm doing that, of course, I'm still doing my research. And my research as an academic involves dealing with other researchers at other universities. And we've done that for many, many years. It's called collaboration, and it's what we do. Recently, with one of those collaborations, we solved the structure of one of our viruses. And it was obviously published, as a peer review type of paper. But the implications of that structure told me immediately how to make new vaccines and how to make new antivirals. So again, I went back to WARF. And I said, we have this collaboration with Purdue, and we're doing this new technology now. We have new ideas. So there were new IDRs and there were new patents that had to be filed, but this time including University of Wisconsin and also my collaborators at Purdue. So WARF has got all this wonderful technology floating around out there, plus our reagents. So more pharmacos want in, right? And so pharmaco number 2 or number 3 or number 4 starts going to WARF and saying, hey, we want in, we want MTAs, we want your reagents, we want licenses for this stuff, and oh, by the way, we want Anne to consult for us, okay? The problem is that no two pharmacos will speak to each other. They are deathly competitors, some of them having competing technologies, and they both want to talk to me, or they all want to talk to me and say, we're doing this, we're doing that. Do you know what the other guy is doing? Have they already tried this, and does it work? Okay, a big conflict of interest there, right? So the consulting contracts that go into this sort of thing become really hairy because what I know is public information, but what I got from them is not, okay? Now, you'll notice there's a big blank space still up there. Well, that gets even more complicated because, of course, there's the venture capital guys, right? And they sit there and they say, well, this is really cool stuff. Why don't we have a startup? And if I have a startup, I got to go get money. And if I got to go get money, I got to prove to those people giving me money that I have the technology and the sole rights to the technology. And moreover, I've got all the right people on my board of directors. So why don't we hire Ann and put her on the board of directors, okay? So these are all situations that have come up within the last year, and as you might imagine, a whole lot of these have potential for conflict of interest, major conflict of interest. I don't have a lot of contracts that are signed right now. I avoid them like the plague because of the potential for this, but you can see that there's a lot of conflicts that can happen here. As soon as money or a contract is exchanged, you have the potential for conflict. So these are the kinds of situations that face, you know, a typical researcher like me when you actually come up with something that's useful. Right? Things like this come up into the public sector. So I'm going to stop there because we'll have a chance for discussion later, and just leave it to you to see that all those pink arrows are places where I have no training, right? And that's why we have tables full of lawyers here to help out folks like me. Thank you.
Thanks. And you can stand up here if you like.
Printed my slides. So Rochelle and I are here on behalf of UW. We'll be representing UW. And like I said before, I work in the Conflict of Interest Office in the Office of Research Policy. That worked. So much of what I work with or centers on university policy, federal regulations, state statutes, and then also system policy. Our main regulation that most of our work revolves around is the Public Health Center or Public Health Service regulations. And we mainly work with investigators on filling out their outside activities reports and then reviewing them, and then if need be, assigning a management plan to them. So one of the things that comes up a lot when we talk with people about their outside activities is their time commitments. So while the Wisconsin idea does encourage people to engage with the outside world, and our office definitely also encourages you to participate in outside activities, it does not sanctify the outside activity on behalf or at the expense of carrying out your UW responsibilities, and that would include your research, teaching commitments, and publishing commitments. And really, you should be working with your department chair or center director to be able to find the right balance between your outside activities and then your work for the university. And that might mean 20%, like there's the 20% rule, but it also might mean 0%. If you're not getting your university work done, you should not be working on any outside activity. And that being said, once you do participate in these outside activities, you need to report that to us. And this includes all faculty, regardless of appointment, academic staff at 50% or greater appointment, anyone who's listed as a study team member on a human subjects protocol, and also anyone who's listed as PI, COI, or key personnel on a federal grant. All of those people need to report to us anytime they have an outside activity that's related to their university work. And if there any changes to your outside activity occur, you need to tell us within 30 days. That includes any change in the relationship. If at first you were only consulting and then you got some stock options, and so now you have ownership in the company, you need to report that to us. You also need to tell us when if you receive any sponsored research from that entity, because that can kind of have a role on your participation in the research. And then if you get any new outside activities, please be sure to update us on that throughout the year. I think I'm behind a slide. And then once we get those outside activities, it's my job, as well as one other person in my office, to review that report and then see if there's a nexus between your outside activity and your responsibilities at the university. And we interpret that nexus pretty broadly. It's mainly just what any reasonable outsider might think is a nexus. So we're not going to go into the nuances or intricacies of what is this type of research, because we don't have the expertise to do that. So if you're consulting for a pharmaceutical company and you're in the Department of Surgery, you're probably going to end up with a management plan. You also do have to meet certain financial thresholds. So if you do have that ownership or do receive compensation at a certain level, between that and having a nexus with your research at UW, you're going to end up with a management plan. But having a management plan isn't the end of the world. It really is just the institution's recognition of best practices to be followed when conducting research. And a lot of our management plans are actually just university policy reiterated in our plan. Some of the main aspects or key aspects of our plans are disclosure, higher standards, and restrictions on human subjects, which I'll go through a little bit. Also research support and purchasing requirements, as well as other considerations for time and effort reporting, like I've already discussed. I think I missed a slide. So like I said, I did want to go over the human subjects portion of the management plan briefly, because that's the one that causes the most concern for researchers. So if you have an entity that is either sponsoring your study or owns or licenses a technology used in the study, you're generally not allowed to participate as PI or key personnel, especially if the study is greater than minimal risk. We do still allow participation in no greater than minimal risk studies, but the IRB still can require you to make disclosures in consent documents or even prohibit you from participating in recruitment.
All right, so I'm Rochelle Martin. I'm with the Office of Industrial Partnerships. And so I just want to see if anyone here who knows what the Office of Industrial Partnerships is could raise their hands. Okay, only 2 people from my office raised their hand. So good thing I included this slide. I just wanted to give everybody a little bit of information about who we are, because we are relatively new to campus. So we've been around since 2012. We do serve as kind of a central point of contact for a bunch of different types of agreements on campus. We do focus mostly on the industry-related agreements. And we do a bunch of different types of agreements. So we do industry-sponsored research, the industry-sponsored data use, facility use, confidentiality agreements, fee-for-service agreements, incoming, outgoing material transfer agreements. Not on that list is consulting agreements. And so you might be wondering why I am up here, but that's because we also serve as a resource if you have questions about the university policies, about some of the state laws that might apply to the work that you do at the university, and then how that might actually impact the activities that you undertake as an individual. And so I have some legal stuff up here. The first one is a Wisconsin statute that says that a state employee is not going to be allowed to be involved in the making of a contract or performing obligations under a contract with the state in which that employee has a pecuniary interest unless, and then if the contract is less than $250,000, then you're all right. That is over a period of 24 months. Or if it is over $250,000 over that period of 2 years, then we do go through a process of getting approval. And then we also have another set of statutes that we refer to pretty regularly, and that's going to be with Stat 89382 and 89546 sub 1. And basically what those state are that the university can assume liability for its employees when its employees are acting in the course of their employment. And so we cannot assume liability for you when you're outside of the course of your employment. That's just a very important distinction that we like to draw. Because when you are doing university-related business, when you are doing research on campus, we absolutely want to be there for you if you get into trouble. So now we have some policy stuff that we want to talk about. Really important to this discussion is the Board of Regents policy document 20-22. That section is the Code of Ethics. That is where it is stated that a university employee cannot use university resources for their private gain. And so that's really important when we start talking about why the university can't advise you when you're undertaking consulting activities as an individual. We do have a conflict of interest because as employees of the university, we are supposed to be doing what's in the best interest of the university. And what's in the best interest of you as an individual is not always going to align with what the university wants. Also, we are a university resource. And so if we're giving you advice and what you can do in your individual capacity, that is a use of university resources for your own personal gain. And then we also have UW system policy. So I only reference policy 342, which is an overarching system policy, and it incorporates a few other really important policies that apply to the performance of research on campus. And so one of the first sections that I wanted to draw attention to is the section where we do not agree to publication restrictions. So we are an academic institution. The work that we do here is of interest to the general community, to the research community, to the public at whole. And so we want to make sure that we're not going to agree, that we're not going to share the work that we're doing on campus. And then we also have our patent policy, and that's separately stated in policy 346, but in general, what it states, and this is a nightmare for the lawyers on campus, what it states is that you as an individual, inventor of an invention on campus, will own that invention unless there is a federal obligation or a contractual obligation that states otherwise. And so what that means is if you have something that you created using federal funds that you obtained under a grant, that would implicate the Bayh-Dole Act, so that might be a federal obligation. And if you have a contractual obligation, that's something that my office typically creates for you. That means that a company wanted to give us some research funding, and in exchange for the provision of that research funding, they also wanted to ensure that they would get access to any inventions that you would create through the performance of that project. Another section that's worth referencing is the copyright policy. So we also don't make a claim to your copyright unless you were specifically hired to create that copyrightable work as a condition of your employment, or if there are significant university resources. So typically, if you are going to write a publication, we're not going to claim that we own that. If you're going to write a report for a project, we're not going to claim that we own that. And then the last section that I think is really worth mentioning is that we do state that we retain ownership of all data that we produce in the performance of research. And that does tie back into a couple of the other sections here because we want to make sure that we retain the right to disseminate the results of our research, and we don't want to be giving that away to industry so that they can prohibit us from doing that. And so some people here might be a little bit more familiar with the campus policies. Campus policies don't change the system policies. They just restate or clarify or even sometimes narrow the system policies. We have a relatively new policy that was established late last summer, Policy and Procedures on Academia Industry Research at UW-Madison. There's a number of sections in there. I think most importantly what it states is that we do not assign rights in our intellectual property to third parties, what it is university-held IP. It also affirms disclosure obligations, so if you invent something, you are required to disclose it to the university. Something we encourage is that if you invent something in your individual capacity, you may also want to disclose that to the university, because we will perform what's called equity review, and we can give you a letter, and it's something that Anne alluded to, we can give you a letter that states that the university does not have an ownership interest in that, so that if you are going out and doing consulting or starting a company, you will have that in writing from the university. And then it also provides just an update on what we consider when we're looking at the commingling of funds. That's very important for Bayh-Dole purposes, but also very important when you are working with more than one industry sponsor. And then we also have two other policies that restate some of the system policies, the policy on data stewardship, access, and retention, which kind of speaks for itself. It does talk about ownership of data. It talks about our obligations to retain the data and records of that data, and then how we can share that with outside entities. And then finally, we have our policy on tangible research property. Thought this one was really important to mention because what it states is that while you may own the intellectual property in a material, the university owns the research material itself. And so if you were to go do consulting with a company, even though you may independently own that IP, you can't just take the material off campus and give it to them. So that's something that you would work with my office on. and we could try to make sure that that's handled appropriately and in accordance with the policy on something like a material transfer agreement, or if it is a WARF-held material, then you would want to obtain a license. So now I'll turn it over to Jeff, because I think I just proved that it's really not as easy as just going out and entering into your own contracts on your own time.
That is true. So I'm Jeff Glazer. I work with the University of Wisconsin Law and Entrepreneurship Clinic. In light of the Stanford v. Roche decision that came out 5 years ago, the university legal department came to us and asked if we would be available to be a resource for faculty members here on campus who are engaging in outside activities. Needless to say, Stanford v. Roche caused quite a stir amongst the university legal departments. And the nice thing about us at the university, at the LNE clinic, is we do not represent the university. So the things that I am telling you are not official university policy, although they might be. That's the nice thing about having official UW attorneys up here with me. But when I speak, I don't speak on behalf of the university, which means I'm allowed to represent you personally. And so our representation of faculty is one of the few instances where the clinic does in fact represent people in their individual capacity. Interestingly, all of the things that Anne showed on her first slide are things that we run into at the clinic when faculty come to us with their arrangements. So if you're interested in getting involved with the LNE clinic, you think I have an outside activity and I have been presented with a contract, I would like some legal advice, we have a process. So we have a form on our website that you can fill out. You just put in there that you are UW faculty, that you have a contract that you'd like us to look at, and we will get back to you typically within 24 hours. I will probably be the one getting in touch with you, and I will say, it's a pleasure to meet your acquaintance over email. Could you please send me your contract? A student will be in touch with you shortly to set up a meeting time sometime in the next 2 weeks. We do not typically work that quickly. We use students to do our work, and so unsurprisingly, we tend to be a little slow. With you guys, we actually turn on the heat and work pretty quickly. So in that interim between when you send me the contract and when you set up and when we actually meet together, the student and I are reviewing your contract for a lot of the things that we're going to talk about on the next slide. When we come into that meeting, we'll talk a little bit about some of the concerns that we have. We want to hear some of the concerns that you have. Often we're just getting that contract and we have no idea what it is that you guys do. So we'll spend a little bit of the time trying to get up to speed on what exactly you're trying to accomplish with this relationship. We'll redline it together, and then we will send you a final red line that you can then forward on to the company and say, these are the concerns that I have. We don't often undertake that relationship ourselves. It kind of gets a little weird. So we typically have the faculty member engage directly with the company they're trying to consult with, although we're providing some guidance on the back end. So we occasionally then get some feedback from the company. More often than not, it's everything looks good. But every now and then they say, no, we don't like the red lines you made. We actually had a reason for wanting that clause. And so then we have a bit of a back and forth. Usually we've only had one deal go bad. Everything else has been fine. So we can almost always work out the problems. Like all of the other members up here have said, in general, we want these things to go through, right? We want you guys to be able to enter into these relationships. We as attorneys, believe it or not, are not here to get in the way. Sometimes seems that way, but we are not here to get in the way. We're here to just make sure that we're acting in your best interests. So what do we typically look for? This is a long list of things, and this is just a small list of the things that we typically look for. The column on the right-hand side, you'll notice, are things that are related to UW policies, right? So you have things like intellectual property rights, the use of institutions' property, the use of the institution's address and email address. Remember, you are engaging in this activity in your personal capacity. Using UW's address or UW's email to engage in this activity, probably not a good idea. Not the least of which is that's technically subject to open records requests. So keep that in mind next time you're engaging in your consulting arrangements. The institution is not a party to the agreement. This is a lot of the reason why Rochelle is sitting here before you. We do a lot of work together, and sometimes things that start out as sponsored research end up as consulting arrangements because they realize the university has it won't negotiate on publication rights. And they realize that maybe working with the university isn't the greatest idea, so they want to hire the person individually, or vice versa. It goes the other direction as well, where what starts out as a consulting arrangement ends up as sponsored research. So the stuff in the left-hand column are things that are a little bit more personal to each individual. So things like publication restrictions, insurance, confidentiality, whether you're getting fair market value for your time, right? Things that are personal that, the university, even if they were able to comment on some of the things on the right-hand side, would have no clue about on the left-hand side. So we work with the individual faculty members to go through the contract, and these are the kinds of things we typically look for. I'm going to spend the next few slides looking at some actual contracts. This is the exciting part. We're going to look at some actual contractual language that we've seen to give you an idea of some of the things you should be looking out for. Example number one. This isn't what you should be looking out for. This is something that we add to every single contract that walks through our door. We affectionately call it the UW clause, and it's a lot of words. I've actually broken it up for readability, believe it or not. But what this basically says is you are a university researcher. Your primary job, your primary obligation is to the University of Wisconsin. If there is a conflict between your primary obligation to the University of Wisconsin and this contract, the UW will always win. And that's essentially what this clause says. This clause says, if there's a conflict, UW wins. So here's something that was in an actual contract. This one actually isn't too terrible, but it is relatively recent. I won't tell you who the company was, but it was a big company. And this relates to presentation and publication, right? So here at UW, you all have the academic freedom to publish whatever it is that you like and explore the research that you deem appropriate in your particular areas of interest, right? So you go out to industry, like Ann said, you go out to industry, and they probably don't want you telling other people about the stuff that you're telling them, right? So they say, we don't want you publishing the stuff that you're doing while you're here. But occasionally you go out there and you do some pretty interesting things, and it might spark some ideas for the research that you're going to go and then do back in your laboratory. You get out there, you work with some folks, and you say, oh, that's actually pretty interesting. I might want to explore that in my laboratory. A clause like this might prevent you from later publishing on that. And how could it later prevent you from publishing on it? Consultants shall not present, publish, or submit for publication any work resulting from the services. Any work resulting from the services, right? You go out there, you do some work out there, you get an idea, right? It results from the services. And then you go back to your lab and you want to explore that. This would prevent you from publishing those findings, right? Even in the abstract, right? Even if you're not going back and using specific company information, because it resulted from the services, you would be prohibited from publishing. So in this case, we redlined, we crossed out resulting from the services, and we substituted what we felt the company was actually concerned about. The company is actually concerned about you disclosing their confidential information, right? That's what the company cares about, right? They're not usually concerned about your continuing to research in the abstract, right? What they're concerned about is you going out and disclosing their confidential information. So we substituted resulting from the services with containing confidential information. So we felt that was appropriate. Company accepted that, right? Just one of the areas where we frequently see some problems is in publication. Area number 2, non-competition. So here we end up with 3 different ways in which this could affect your work in your lab by going out and doing a consulting arrangement. This also came from an actual consulting agreement. And what it says is, during the term of this agreement, the consultant will not directly or indirectly provide any services in the field of interest to any other business or commercial entity. Right? So this could arguably impact your UW or sponsored research. Right? You should not provide any services, you may not provide any services in the field of interest. Right? That's pretty broad. Well, it depends on what the field of interest is. You shall not provide any services in the field of interest. You shall not provide any services to any business or commercial entity that is competitive with the company. Right? So you go out and you do these services, and then a competitor comes to the university and wants to do some sponsored research in your lab. This would prevent you from accepting that. Right? This would prevent you from accepting sponsored research from a competitor in the industry. Participate in the formation of any business. So again, this would impact your ability to form a startup around some technology that was in the, quote, field of interest. Right? You now cannot start up a company in the field of interest, right, by agreeing to these things. So unsurprisingly, we would work to narrow this down quite a bit. And we can do that in any number of ways. We can just simply scratch these things out, right? We can make the, quote, field of interest, right? We can define that sort of any way we want. So we can make it really, really narrow, right? There's a whole lot of ways in which we can work with these contracts. The last sentence is one that's pretty interesting. It says, advisor shall notify the company of all other consulting agreements which advisor has entered into or any consulting services which advisor may provide to any third party. Right? So for many of you, you don't just consult with one company, you probably consult with a number of companies. You now have to tell this company every time you enter into one of those. Right? It's kind of a pain in the ass. Not impossible, but it's just something you have to do. Right? Whenever we have these kinds of affirmative obligations, the reality is nobody ever does them. I don't like to work in the abstract. I like to work in the concrete. If nobody's actually going to do it, then we should take it out of the contract. Right? If nobody's actually going to do it, we should take it out of the contract. The next is intellectual property. Service provider grants to the company a perpetual worldwide license without royalties to use, reproduce, modify, adapt, or exercise all intellectual property rights in and to the service provider property for the purposes blah, 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 right? You go out there and you have some stuff that you're working on in your lab and you say, hey, if you adopted this technology, it would make your processes go a lot more smoothly. You have now given them a worldwide perpetual royalty-free license to use that thing you just suggested they used. You may not have the rights to do that, right? You may not want to do that, right? Because part of the way that you make money, or whoever owns the intellectual property makes money, is getting a royalty on the use of that thing, right? But by going out there and suggesting its use or showing somebody how to do it, you have now given them a worldwide perpetual royalty-free license, right? So we tend to cross these things out because they're just not appropriate. And frankly, you may not have the rights to grant this, right? If you're going out there and the piece of technology that you're showing them is something that you're under an obligation or WARF has already patented, you simply do not have the right to grant this, right? And this is Roche. This is Roche. So we try to cross these out wherever possible. So I just want to sum up a little bit with some consulting pro tips here from things that we see frequently. Don't use your UW email or physical address, right? Use your home addresses, start up your own consulting company, and find a different address to use. Know the status of the intellectual property you are working on campus, right? Does it belong to WARF? Does it belong to you? Who actually owns the stuff that you're working on? As we heard Stephanie say, the 20% rule isn't a rule, right? There is no written down 20% rule. That's not a thing, right? So while it's a general framework and guideline, nobody here would commit to saying 20% as a rule. You must disclose your outside activities. So we would make sure we would work with you to understand that you do have that obligation. We would work with you to narrowly tailor and be explicit about the services you are providing so that the contracts don't overreach. Right? There's a lot of ways you can get in trouble by being abstract. And a lot of companies will say, oh, well, we don't know what you're going to do when you get here, so let's just make it broad. So that way, when you come here, you can kind of do whatever, you can just do your thing, right? You can just come here and do biochemistry, right? And then if you have any questions or you have some concerns about the contracts and how they apply to you, get in touch with me. Apply to the Law and Entrepreneurship Clinic. We're here to help, and we're a free resource to you. So I think I may have forgotten to mention that we do not charge you for our services. I get paid by the University of Wisconsin, so your tax dollars pay for me. And that's all I have.
Any questions? We'll open the floor now to questions. And we have a last slide here that just provides the information of the people who spoke in their contact information.
I'm Joanne Oravec from the University of Wisconsin at Whitewater. I'm just wondering about how graduate students get folded into some of this. Grad students are doing significant research, and I'm wondering how their contributions are recognized in a way, of course, that signals that the faculty advisor is still in charge, but that the graduate students are not slaves. On the other hand, I know that you have a lot to say.
Yeah, so this is actually an area where we've started getting more involved lately. Working with students is kind of a slippery slope for us, so we don't want to be in the habit of just being free legal counsel to every student here on campus. But on the other hand, we do recognize that grad students working in labs have an obligation to the intellectual property that's being worked on in those labs. So we have worked and we do work with grad students, research assistants, and whatever other titles might be in your labs. If they're going out and doing consulting arrangements that are related to the work that they're doing in your lab. It wouldn't just be, I got a summer internship kind of thing. It would be, I'm going to, when we've worked with them, it's this company is somehow related to the lab work that I'm doing. And so I'm going to go out and do the work with the blessing of the PI. And we're working on things that that may also be being worked on in the lab.
One of the very early slides, I think there's a system policy, stated that the position at the UW could not be used for personal financial gain. Mm-hmm. So how do you get from that to allowing faculty to be paid for consulting or expert witness work? It seems to me, on the face of it, to be contradictory. So lead me through the steps.
Sure. So we don't consider you to be wearing the hat of a university employee all the time. So when you are on campus, and we like to use this sort of idea of hats, and you wear your university hat, and then you can wear your individual hat, and it's just easier for us to conceptualize that way. So when you have your university hat on, the work that you are doing is going to be work that you are undertaking as an employee. So it's something that you're here on campus to do. So when you are a researcher, you are working in a lab and you have a field of research, you may be teaching, you may be working with grad students, that's going to be the job that we expect you to do when you're here. But when you are not doing that job, that's typically when you're going to be doing something like consulting. And I know that sometimes it's kind of hard because the lines can be very blurry. And sometimes we do have researchers who are asked to do things in their individual capacity, but they're not comfortable doing that outside of the university, because we do also encourage outreach and we want to help our researchers get out there. And so we have situations where a researcher will say, I've been asked to do this as a consultant, but I would really prefer to run it through the university, kind of get the university's blessing on this, and we will usually process that as something called a fee-for-service agreement. Or sometimes it turns into sponsored research, because we are able to do sponsored research off-site. And so I can understand why there's that gray area that might be a little bit confusing.
That was very helpful, thank you. And I have one other point of clarification. changes in consulting, outside activities should be reported to us. So as a department chair, I get the question, do I report to my department chair? Do I report to my dean? Do I report to campus conflict of interest? What does reporting to us mean?
Well, any change in an outside activity does have to be reported to my office, so that would be an update to your online report. But a lot of departments do also require that you go through your department chair just so they know about your time commitments and the time away from campus.
And that decision would be made at the department level? There's not a uniform policy?
Yeah, that's all at the department level. We leave it up because every department is different based on the type of research you're doing.
And faculty that have some percentage extension appointments?
We take that into consideration when we review an outside activities report, because not everyone has a full-time 100% appointment. So we do recognize that if you're at 50%, you're probably going to be doing more outside activities than someone who's at a full-time position.
Hey, Mark Ferrugia. I work at the VA hospital. I wanted some clarification on one of the pro tips that Jeffrey brought up towards the end in his talk. You mentioned in order to protect oneself, try not to use university email and physical address, obviously. Have there been occasions where a primary researcher at the university has done consulting work and their use of, say, university databases or access to journals in order to perform their consulting has caused any friction with the university?
I can actually speak to access to journals and databases. So we would encourage that researcher in their individual capacity to have the company that they're consulting for enter into an agreement with the university through which we could make the data available, and then they could be free to use that in their consultant capacity while they're working with that company. They themselves could not just provide that access. And as far as getting access to things like journals, I know that through the university and through the library, usually you will be able to get access using your net ID. And we've had circumstances under which we've had researchers say that they're going to share different articles that they've pulled up about relevant research projects and share them with the company that's coming in. And actually the license that we have with those providers through the library does not allow for us to distribute those articles widely. There's a very limited academic, university-related use restriction placed on those.
So would that be basically the same, you would expect the same agreement between the company and the university for use of the journals as well as the databases? Is that essentially what you're saying?
They would need to get those articles directly from the journal. So we could provide citations. They would just need to go and obtain the actual articles themselves. Okay. The university, since we don't hold the copyright on any of those articles, that would be held most likely by the journal, wouldn't be able to enter into any sort of agreement to further distribute them.
Quick question. I'm a research administrator over in the School of Medicine and Public Health. And a lot of times when we're putting out a grant or if we have a grant award, we have a consultant on it. Should we be concerned at all with regard to outgoing or hiring consultants, with regard to what terms and conditions we put on them and or conflicts?
So I know those are typically going to be handled through business services. So when we're procuring services, it is a little bit different. But I know from speaking with some of the individuals responsible for those that we kind of have the same expectations of when we're hiring someone as we would if the roles were reversed. And so if it's something like copyright that we want to maintain ownership of, then we make sure that we call that a work for hire in the contract. They are, as an individual, going to be responsible for managing their own conflicts of interest. And so, I don't know what we would do if we would see something like that UW clause that Jeff mentioned. But I think we would make it very clear what our specific deliverables are, and then just make sure that they're assigning the ownership of those to us, or at least giving us the license that we need.
Any other questions?
Completely hypothetical.
Oh, I think we have to
Involved, let's say, with
I think we're, hang on, I think we're waiting on a microphone.
Oh, yeah, let's say
It's being
hypothetically,
recorded, so
you're already involved with an agreement, right?
Yeah.
Where do you start? Yeah, hypothetically,
Hypothetically.
you're already involved. Where do you start? You know, which of you, where would you start?
So, I mean, that's a really good question, right? And we've had PIs or faculty come to us and say, we've already entered into this agreement. There's a couple of choices. One, you're kind of stuck, right? You've already signed that agreement. So you have basically two choices from there. One is deal with it. The other is to renegotiate it on some term, right? Based on some reason, right? And so we're going to consider the engagement over, and now we're going to enter into a new agreement. Or some other reason that would give you a hook for saying, we don't think that contract should apply anymore. If it's something super problematic, getting the company to agree to amend so that you can clarify or get rid of something. I do know that a lot of companies out there are sympathetic to the fact that working with university researchers is different. A lot of the contracts that we see, a lot of the contracts that the university researchers are given are the same contracts that they give to everybody that walks through the door, right? And so that's why we end up making a lot of the changes that we make, because the university context just isn't appropriate for the same contract that would be for some other outside consultant. So to go back and say to the company, hey, I actually went and read that piece of paper that you gave me that I accidentally signed, and I realized that I probably agreed to some things I shouldn't have. Would it be okay if we, clarified, my university obligations in this contract? And reputable companies should. Right? If it's something serious enough, if it's, hey, you're not paying me enough, I don't know that that's a reason to modify it. But it's, hey, I don't have the ability to give you a license to this thing. We need to cross that out. Most companies should agree to that.
I think if you can get in front of that problem, we communicate very regularly, and so, as it's been kind of mentioned before, it can be difficult to decide what side of that fence you're going to fall on, and sometimes it truly comes down to personal preference. And so if you just have questions about what type of arrangement you may be entering into or that you want it to be, then you could come talk to any of us, and we can make sure that you get funneled over to the right office.
We have time for one or two more questions. Go ahead, Tim.
Could you talk about the pros and cons of signing a consulting agreement as an individual versus setting up an LLC for that purpose?
Yeah, so this is a really good question. We actually get this quite frequently. There are two reasons why you might want to form an LLC or some other arrangement. The first is you just do a lot of it. Right, and so it's an easy way to sort of contain that work into a single entity and to be able to shop your services around under that entity. The other reason is liability. One of the things that we didn't get into, but that we do see frequently in contracts is companies don't want to be liable for anything. And so they push as much of it off onto you as they can. And they say, hey, we're hiring you to come in here and do things. If you tell us to do something and we do it and something goes wrong, you should be liable for that. Sometimes that's appropriate. Sometimes it's not, right? It's because sometimes the things that you're telling them to do is you should just push that button. I'm not responsible for the consequences of you pushing that button. Right, and so being able to insure away that obligation, right, having an LLC under which you hold malpractice insurance, for example, or what we might call errors and omissions insurance, is often a good habit if you're going to do it regularly. right? So that way it covers general professional services negligence and just kind of the things that you go out and do, and somebody follows what you tell them to do and it screws up. Right, it happens, right? So having an LLC, having that EIN, being able to do it, get a 1099 underneath the LLC is also just that one more step removed to show the university that, hey, this isn't related to the university stuff that I'm doing.
One more question, or we can break. Great, I think we'll wrap this up. We'll have a reception outside. Thank you for attending. We really appreciate your attention.